Let's talk about what you and I do. We're attorneys and we're handling these cases. How do people go about, selecting an attorney, and what are the things that an attorney is going to look at, and how do we evaluate cases?
Sure. So every law firm does things differently. You and I have been working together for a long time, and I think we have a pretty good formula for helping clients understand what needs to be done to process a claim. You have to realize that, and as an attorney, that most of the people who come into contact with us have never filed a claim before. They've never been involved in the legal system before. So this is new and it's scary, and we appreciate that. So what we try to do is give as much personal attention as we can to each individual client, recognizing, of course, that we deal with thousands of people from around the country, and we have to give our time to everybody. So we do our best to make sure that we give them the personal attention that they need, but at the same time, our communications are not only in person, but maybe through email or text, and certainly we send out regular status letters. The first thing somebody should do is give us a call. We can talk to them. Either I'll speak with the client or somebody on my staff, one of our attorneys or paralegals who are well trained in dealing with the TDF project and understand the science. And we have an intake process where we ask certain questions. We'll certainly ask about demographics, a little bit about your background. We'll ask you about your medical history. And then we'll start asking about what drug you took and when you started taking the drug and at what dosages. And then we'll ask you about what injuries you suffered. Was it a kidney injury? Was it a bone injury? Was it a tooth loss injury? And those are the type of things that we go through. The intake process is not long. It should be about 10 or 15 minutes. It gives us enough information to answer the question, should we investigate further? And if we get through the questions and we see that there's the information that we need to potentially make a case that they took one of the TDF drugs and they suffered one of the injuries that we're looking for, we will then send out a retainer agreement, which is just a contract between the firm and the client. And we will send out requests for medical records or authorizations for medical records, so we can ask for the medical records. Sometimes we may ask the client, as we talked before, to get their own pharmacy records. Sometimes we'll get pharmacy records for the client, depending upon a whole bunch of factors. And once we get the records and the pharmacy records, we're in a position to evaluate it. And sometimes we can speak with a physician. Sometimes we have enough in-house experience. We know that it's a case or not a case. And then we go from there.
Will a client have to pay any out-of-pocket expenses to get medical records or to compensate our firms?
The answer to that question is straight out no. We don't ask money from our clients. We front the cost for all of our clients.
And what about our fee?
Our fee is on a contingency basis, so we don't charge our clients by the hour. As a contingency fee law firm, as contingency fee law firms, we only get paid if the client makes a recovery, either by settlement or verdict, and we take a percentage of that particular settlement or verdict. From that recovery that the client gets, we expect to be reimbursed for our costs, for our out-of-pocket expenses. But if we do not recover, if the case does not win, we don't expect the clients to reimburse us for the out-of-pocket expenses that we put forward.
In addition to getting compensated for themselves, are there other reasons that people might want to bring these claims in terms of trying to affect what Gilead does in the future?
Yeah, that's a really good question. Not all clients do this for financial compensation. Some clients are just angry and they don't want other people to suffer the same fate. And they know that if we can go out there and make a stand, I'm mad as hell, I'm not going to take it anymore. That pharmaceutical companies, insurance companies, big business, corporate executives shouldn't be allowed to take advantage of the little guy. And it's a rare opportunity that you have to stand up and fight Goliath, but this is one of those times.
And it's through this collective action of everybody bringing these claims that one person alone going up against a company that's selling $11 billion, it would be an impossible task. It seems it's only something that could take place by a large number of people coming forward and working together.
Yeah, that's exactly right. One lawsuit is impossible. It's financially impossible to bring these claims. As you know, Mike, takes millions and millions of dollars to prosecute these cases. And so that is why law firms from around the country get together and they pool their talents and their resources to take on big pharma.
What is it about our firms and our experience that makes us perhaps a good choice for people to look at when evaluating an attorney?
Mm-hmm. Well, I didn't lose all this hair for nothing. I've been doing this for a while. The first lawsuit I ever filed back in the mid-'80s was a case actually on behalf of a woman who developed HIV from blood and blood products. The first 10 years of my practice was designated almost exclusively to representing people who got HIV from blood and blood products. And so it's a big part of what I've done in my practice, and now it's sort of coming full circle. So working over the last 3 decades with you and with others doing drug cases, medical device cases, blood cases has given us the experience and the know-how to put together teams of people that we need to work. And different people around the table bring different talents and different skill sets, and if you put together the right team, you have a shot at going against such a big company. And more than a shot, you have the upper hand.